Good day, everyone. I'm Jonaline Ann Viquilla together with Lear Ann Cabernet. Welcome to our presentation on REM 101, How Ownership is Held. Real estate ownership or a fee simple estate can be held by one person or by multiple co-owners. The form of ownership you choose is critical because it dictates your legal rights regarding sales, inheritance, creditor protection, and tax implications. Why does the form of ownership matter? First, it determines who must sign listing contracts, offers, and deeds. Second, it defines title vesting where the purchaser chooses how to take title based on their legal status. Ultimately, this choice impacts your right to sell without consent, who inherits the property, and your overall tax and creditor liability. When title to real estate is held by just one person or a single organization, such as a corporation, it is called ownership in severalty. In this form, the owner is the sole owner and has exclusive rights to the property. When two or more parties hold title together, they are co-owners or concurrent owners. If they cannot agree on the property's future, a partition suit can be filed to legally dissolve the ownership. One common form is tenancy in common. Owners hold an undivided fractional interest in the entire property. There is no right of survivorship if an owner dies. Their interest passes to their heirs. However, owners are free to sell or mortgage their share without the consent of others. Next is joint tenancy, which features the right of survivorship. This means if one owner dies, their share automatically goes to the surviving owners until the last survivor holds the title and severalty. First, A, B, and C share the property under joint tenancy, which includes the right of survivorship. This means that if one owner dies, their share automatically goes to the remaining owners. So if C dies, A and B now fully own the property together. Joint tenancy can be severed. For example, if three people are joint tenants and one sells their interest to a new party, that new party becomes a tenant in common because the unities of time and title were broken. The remaining original owners remain joint tenants with each other. To create a valid joint tenancy, the four unities must be present. Number 1, time. All interest must be acquired at the same time. Number 2, title. All must be acquired by the same deed. 3, interest. All owners must be hold equal shares. Last, number 4, possession. All have undivided possession of the property.
Now, let's talk about the tenancy by the entirety. So this is a very specific form of ownership reserved exclusively for married couples. Under this legal framework, the owners act as one single invisible unit. Because of this oneness, it requires both signature for any sale or transfer of the property. Think of it as a special version of joint tenancy, specifically for a husband and wife. A key protection here is the title can only be conveyed by a deed signed by both parties. So one spouse cannot independently sell or give away their half interest. So essentially, it protects one spouse from the other's individual debt and ensures neither can sell the family home without the other's consent. Next, we have the community property, which is based on the idea that the husband and wife are equal partners. There are two categories here. First, we have separate property, which is anything owned before the marriage or received as a gift or inheritance during the marriage. Second, we have the community property. Includes almost all other properties acquired during the marriage. It requires both signatures to convey. An important right to note is that upon the death of one spouse, the survivor automatically owns one half of the community property. So in community property states, it doesn't matter whose paycheck paid for the house. It was bought during the marriage. It belongs to both equally. Moving into trust. A trust is a three-party arrangement. A trustor conveys the title to a trustee, who then holds and manages it for the benefit of beneficiary. The trustee has what we call fiduciary relationship, meaning they are legally bound to act with the utmost confidence and trust. We often see living and testamentary trusts, which are established by agreement during the trustor's lifetime to manage assets and crucially to help the estate avoid the long expensive process of probate. So probate is the court supervised process of distributing a will. A trust bypasses this, so keeping the transfer of property private and fast. So to visualize this process, let's break down the rules. The trustor is the creator who gives up the property, and the trustee receives the deed in trust and holds legal ownership and title. They must act in the best interest of the beneficiary. Interestingly, the beneficiary's interest in the trust is often legally classified as personal property, even if the trust holds real estate. So, this classification is important for tax purposes and how the interest is transferred or inherited. There are also specialized trusts. A land trust is designed for privacy. The beneficiary's interest is personal property, and their name often stays off the public record. Then we have the business trust, specifically the real estate investment trust. These require at least 100 members who pool money for large-scale real estate. To avoid double taxation, under the 95% rule, the trust must distribute 95% of its income to shareholders. This allows small investors to own a piece of large building, just like buying stocks. So real estate investment trusts are great for people who want real estate exposure without the headache of being landlord. Now, let's talk about ownership by business entities, starting with the corporations. So legally, a corporation is an artificial person created under state law. It holds title to real estate and severalty, meaning it owns it alone as single entity. The main advantage is limited liability for stockholders, but the downside is double taxation. The corporation pays tax on its profits, and then stockholders pay tax again on the dividends they receive. So, severalty comes from the word severe. The corporation is severed from the individuals who owns it. Finally, we have partnership. In a general partnership, all partners participate in the daily operations and share full personal liability for all business losses. In a limited partnership, it consists of at least one general partner and one more limited or silent partners. These silent partners are only liable up to the amount of their investment, protecting their personal assets from business debts. So if a general partner gets sued for 1 million and only has 500K, the partner's personal cars and bank accounts are at risk. In a limited partnership, the silent partner only loses what they put in. Now, let's talk about syndicates. A syndicate isn't actually a specific legal entity itself. Rather, it's a broad term used to describe a group of two or more people or firms who join together to pool their resources for a single real estate investment. Think of it as a team up for big project. So while syndicate is a name for the group, they are usually organized legally as either a joint venture or a partnership to handle the actual business operations. So syndicates allow individuals to invest in a multi-million dollar commercial properties that they wouldn't be able to afford on their own. Now, let's proceed to the occupant ownership of apartment buildings. So, when we look at how people own units in multifamily buildings, there are three main types. So, first, we have the condominium. So, here you have fee simple title to your specific unit, while the common areas like pool or hallways are owned collectively as tenants in common. So, second is the cooperative or co-op. In this case, you don't actually own real estate. Instead, you own stocks in a corporation that owns the building. That stock give you a proprietary list to live in your unit. And finally, we have the timeshares. So this is a ownership or a right to use a property for a specific period each year, usually 1 or 2 weeks. So the big difference is that in a condo, you own the airspace of your unit, but in co-op, you own a share of the whole company that owns the bricks and mortar. Now, let's proceed to the special ownership. So, to dive a bit deeper into these special forms of ownership with condominium, because each unit is owned individually in fee simple. If your neighbor defaults on their taxes or mortgage, it has no legal effects on your ownership. You are only responsible for your own unit. So, with timeshares, there are two ways to hold interest. There is fee simple, which is permanent ownership for the specific time slot every year. Then there is right to use, which is essentially a long-term lease that expire after a set of number of years, typically between 15 and 50. So, fee simple timeshares can be willed to their hires because they are real property, whereas right to use is a contractual right that eventually ends.
Thank you for listening to our presentation. We hope you learned something new and gained a better understanding of our topic. That would be all. Thank you so much.